The things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property that'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, welcome to the show. Today, we're talking about the 10 things for business owners in 2024. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and X, formerly known as Twitter. At all of those, you can find us at the handle at INREM Podcast. That is at INREM Podcast. Also, on Spotify, Apple, or any of the podcast channels where you can download an audio, you can do just that. We have an audio version of the podcast. Download it, listen to it, leave us a review. We would appreciate it. With that, I'm going to turn it over to Sean, who has our legal update.
Thank you, Andy. So today, my legal update is discussing the top 3 pitfalls in purchasing commercial property subject to existing loans. So, subject to purchasing of property is very prevalent in the residential market. It happens a lot. There's a lot of activity. There's a lot of subject to transactions that take place in residential. And we're starting to see more and more in commercial. But there are some things that make commercial different than residential, and some pitfalls that if you don't really know what to look for and you're not aware of it, you could run into it, and it will make potentially taking a property subject to existing loans in the commercial space detrimental because you approach it like it's a residential transaction and it isn't. So there's a number of pitfalls, but I'm going to just cover what I have given the top 3. There may or may not be any scientific list here, but it's what I've come up with as the top 3. So the first is the length of the loan. So in commercial, loans tend to be very short. So there's generally a 5-year, 10-year balloon payment associated with commercial loans versus residential. It's 30 years. So the commercial loan might be amortized out over 30 years, or it might be interest only, and it's going to have a balloon in 5 or 10 years. It has to be paid off. The owner has to refinance or sell the property, but or come up with the cash and pay off the loan. But it's a much shorter loan time frame than what you find on a residential transaction. The second thing that you find in commercial is a greater lender involvement or oversight. So a lot of times these commercial loans are not securitized, right? They're actually held by the bank that made the loan. And so these lenders are very protective of their portfolio. They are, consistently monitoring the portfolio. And many times the loan documents have provisions in them that state that the borrower has to provide regular financial information to the lender regarding their business. So the lender can make sure that, hey, this is still a sound loan. Everything's good. And we're going to get paid. And so if you have a very active lender, a lender that has, more involvement than what you find on the residential side, more oversight, they're wanting financial information, they're coming and they're visiting the property, they're making sure that their portfolio checks out and every property in their portfolio is doing well. At that point, you're going to have a lender who's going to come and say, well, who are you? Why are you here? Why are you occupying the property? Why are you operating the property or the business that's operating on the property? They're going to be more involved. And when they find out that you've acquired the property subject to their loan, they, being as protective as they are of the portfolio, they're likely to invoke the due on sale clause and take the steps that they need under the, or they have a right to pursue under the due on sale clause, to basically accelerate the debt and require that the loan be paid in full. So that's number two. The third thing is using the incorrect purchase contract. So there's a number of residential purchase contracts out there that can be utilized for the subject to scenario. However, commercial is a whole different animal when it comes to the transaction, the due diligence. We had attorney Michael Gross on about a month back, and we laid out really the difference between residential and commercial. And commercial is a much more complicated transaction. You should not be using a residential purchase contract to acquire a commercial property. It's going to be a much larger contract. It's going to have different protections in there, greater protections for both the seller and the buyer. It's going to have, different due diligence requirements. It will have a longer inspection period. Maybe there's entitlements such as rezoning or special use permits that have to be obtained. There's going to be a lot involved in the commercial purchase contract. And so you cannot and should not use a residential purchase contract to try to acquire commercial property. So those are the top three things to watch out for when pursuing commercial property subject to existing loans. So the first is the length of the loan. The second is lender involvement or oversight. And then the third is using the correct purchase contract.
All right. Thank you for that information. A few announcements for the listeners. Keep in mind every Tuesday. So today, when you're watching this at 3:00 p.m., we're going to be doing the Creative Finance Collective. The Creative Finance Collective is a collection and a membership of basically lawyers in the space of creative finance from a variety of different jurisdictions that are there to get together to talk about all things creative finance. Sometimes we got a lot of lawyers show up. Sometimes it's just Sean and I. And what we do is we make ourselves available for the hour, really to discuss creative finance, find ways to make our contracts better, find out what other lawyers and other jurisdictions are doing. But really, we're primarily there to answer your questions. So if you have questions about creative finance, you have us captive for an hour or until the questions run out. We're going to make ourselves available to answer questions. But if there are no questions, we're going to move on, and we're going to end the collective, unless we've got a good discussion going on with other lawyers. So make sure you come loaded with questions for the collective. Again, that's going to be 3 p.m. Arizona time every Tuesday. So today at 3 p.m., make sure to be there. You can find it on YouTube, you can find it on X, or you can find it on Facebook. And we'll be taking questions, so make sure to bring those. Happy to go through them. So today, let's get into our topic. We're talking about 10 things that business owners should be thinking about in 2024. Now, I know there's a lot of gurus in the space that want to talk about all the different things that a business owner might do or want to do going into 2024, and that might all be valid. What we want to talk about is, from the lawyer's perspective, the kind of things that we want the business owners to be thinking about, the ones that we guide them as attorneys to be thinking about. So we group those into our top 10. And so number one, to start out, of the top 10 that we think are things that you should be thinking about, is review your formation status with your state of formation. And by that, I mean, depending on what state you're in, Sean and I are here in Arizona, but depending on what state you're in, you formed a company. And you formed a company within the jurisdiction of a particular state. And as part of the formation requirements of that, you had to set up your company in different ways, whether it was a limited liability company or a corporation. You had to file that within the state, and you had to set certain parameters. We have found that it is hugely important to know how you've set it up and to keep that maintained, because there can be legal consequences for you not tracking that. And a couple of things that come to mind initially that are basic things that the common business owner thinks about and then throws away after they form but shouldn't, but are the company address and the statutory agent information. Those are things you set up right at the beginning, but are things you should not forget about and things you need to check on. And Sean, why don't you go into some of the reasons why you need to make sure that information is up to date and there could be legal consequences associated with that information.
Yeah. So you want to make sure that people can actually reach you. You want to make sure that the government can reach you, the taxing authorities can reach you. Anybody that wants to file a lawsuit against your company, as bad as that may sound, you want to make yourself available. If you haven't paid your taxes and the assessor sends a delinquency notice to your address of record, which is all they have to do, and you don't get it because you've changed your address the last 2 or 3 years and never went and updated your address. Maybe you're the statutory agent for the company. You're the person that receives notices and service, and you've changed your address. There is no obligation to track you down. They have an obligation to send it to your last known address. And if it comes back as undeliverable, it comes back as undeliverable, and you don't know about your delinquent taxes. The next thing you know, you have a tax lien, or worse than that, your property sold out from under you. Arizona is a very generous state when it comes to notices of tax liens and tax foreclosures. Other states are not as generous. Other states, you can lose your property pretty quickly if you don't take care and pay your property tax bill. The other is service of process. I don't do litigation anymore, but I did it for over 15 years, and you still do a little bit, Andy. But as well as I do in Arizona, we almost jump up and down in joy if we can't find the stat agent. If we send our process server to the stat agent's address and they're like, yeah, they're not here anymore. They moved, however long ago. And we're like, yes, because what do we get to do? We get to then go and serve the Arizona Corporation Commission, who will then send the service of process papers to the last known address of the company,
which is outdated and wrong.
And the stat agent. And guess what? We wait our 20 days and we've effectuated service. It's valid and enforceable service. Like, we've done what the law allows us to do, and we wait our 20 days and boom, we get that default judgment and away we go. Right. We love it when stat agents can't be found, when people don't change their update their addresses and they just disappear, because we know, oh, great. We don't have a duty to track them down. We just have to show we went to the address of record. They're not there. Oh, guess what? Corporation Commission, here's what the law provides. And we, do our thing and serve it. So, and next thing you know, and how many clients have you had? I've had a handful over the years, if not more, where they've come to me and said, oh, I got this judgment. Said, okay, well, let's take a look at it. And I look at it and I said, well, did they serve you? No, I moved and blah, 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 blah. And they, give this song and dance. And then I look at the affidavit of service, and sure enough, they served the Corporation Commission. And unfortunately, I have to be the one to break the bad news and say, you're hosed. There's not much you can do about that.
Yeah, it's over.
It's over at that point. Yeah, they did what they were supposed to do. And so, a lot of times we think, oh, well, I'm going to give them some address where they can't reach me, or I'm going to be hidden, that type of thing. Don't do that. Now, if you want to have a law firm serve as your stat agent, we do that here at our firm. We'll serve as stat agent. When we receive something, we send it to the address that we have for the client. Hopefully they're updating their address with us on a regular basis. And we'll send it to an email, and we'll do our best to obviously get a hold of them, as much as possible. We will do whatever's in our power to do that. But really you need to stay up to date on that. The idea of you just disappearing and people can't find you, that's actually a really bad idea. It sounds good. It sounds exciting. Ooh, I'm anonymous and nobody knows, my address and this and that. It's like, no, that's going to end badly at some point. If you're not careful.
Yeah, it's going to end real bad. And I think people just get not only caught up in the idea of being anonymous and everything else, but more often than not, this is just something that's done on the front end and I think just forgotten about. And here's the good news, and this is why we put it at I think the top of the list here is number one, is it has big consequences, but man, it's easy to check. Sean mentioned that, yes, you could have a law firm or you can have a stat agent company serve as your statutory agent for your company. But even more of a reason to check it, because these law firms or these companies, they charge fees. Maybe your credit card reached an expiration date
Mhm.
and is no longer paying this stat agent company. They sent you a notice, but your email box is full, so you didn't notice that. And they're not serving as your stat agent, or they pulled out and you didn't update it. It's on you to update it. And you just don't know about it because you're not checking it. These kind of things don't need to be checked every week.
Right.
But, this is a good practice once a year. It doesn't cost you anything. If you're here in Arizona, it's a matter of going to the Arizona Corporation Commission, checking your website, checking their website, and doing a search of your company, and just checking to make sure your information is up to date. I mean, what do you think? This takes about 3 minutes to do?
It
That's
takes
it?
about yeah, it takes about 3 minutes. And the fortunate thing with Arizona is you can form it and forget it. And that's what happens, I think, is people form their LLCs and then they don't have to do annual reports, they don't have to do annual filings, and then they forget to go and check and update to make sure that the addresses are right, that the stat agents are right. However, it is important, um, because it's a major mess. It is important if you formed in other states to check those to make sure you've done your annual filings. I've had numerous transactions where I've been called 2 days before close of escrow from either the title company who wants to refer the client to me, or the client who formed an entity outside of Arizona that has an annual reporting requirement, took title to property here in Arizona, and then failed to file their annual report with that state where they formed. Well, no title, what a title company does before they close, they go and they verify the status of the active status and in good standing status of the LLC. Well, if they go to California, for example, and they see that it's been administratively dissolved and there is no entity, well, then they're not going to close the transaction. And guess what? They're not going to close it until you can go back to California. You can get that, reactivated, get up and running again. And now you may have cost yourself the transaction. Definitely, a significant delay as a result. The other thing is a lot of our clients come to us because they want asset protection. Well, if you go and you form an LLC that has an annual reporting requirement and you don't file that annual report and you end up with administrative dissolution, bye-bye corporate veil. In that case, you're acting basically as a sole proprietor. So,
Right.
Your corporate veil status is out the window and you don't have that asset protection that you maybe paid an attorney to set up for you by, forming these companies. So it's very important to stay up to date. But like you said, you don't have to monitor it every week or every 2 weeks or every 6 months. Just once a month, first of the year, jump on and say, okay, when's my annual report due? What's my address? When's my stat agent? Who, maybe the membership's changed. So you're going to update the member and manager information. But just make sure that everything's on the up and up with your company going into the new year.
So let's move to number 2, the second thing that we think business owners should be doing in 2024, and that is review changes to the laws in your industry. This is obviously important, and that's why we preface this to the laws of your industry, understanding that the vastness of different niches within business are massive, and we certainly aren't up to date on every single change with respect to each industry. Obviously, this is a real estate investor podcast, and we focus a lot on that, but know your industry and know the changes to the law. Sean, three specific examples come to mind right away. These aren't necessarily changes right away, but changes in the last few years that affected a lot of our listeners.
Mhm.
Wholesalers,
Mhm.
obviously anybody in the creative finance space trying to track what kind of laws might be coming down the pipeline. And then the Corporate Transparency Act, which we're going to devote an entire show to, so we won't get into too much detail, but those are just three examples off the top of my head where if you're involved in real estate or just general business and you didn't know about those going into that respective year, you were in a lot of trouble.
Right. Yeah, the laws are constantly changing for businesses, for real estate investors. Um, you have tax laws, you have um, business laws like the Corporate Transparency Act, which we're going to have a show hopefully here in the not so near distant future, all about the Corporate Transparency Act and what that requires. We had Larry West on our show recently out of Texas, who's a enrolled agent and tax preparer, and he went over some of the upcoming changes to some of the tax laws that may be on the horizon. Every year, for the most part, the government doesn't sit still. They're always passing stuff, right? They're always passing stuff. And so you always have to kind of be on the lookout, be prepared, stay up to date, and make sure that you are going to comply with the new laws that are enacted.
Yeah, and jumping and beyond what Sean just said, the government's always passing laws. We're not just talking about one government here.
Right.
There's the federal government.
Yes.
Then there's the state government, and you might even be talking about local municipal governments. Another example I think of are short-term renters,
Yes.
right? Boy,
Mhm.
the law, especially in Arizona, we can't speak to other states, but in Arizona, it seems like every few years, it seems like they're doing a major overhaul, whether it's dealing with HOAs or something else when it comes to short-term renters.
Well, yeah, and outside of Arizona, it's even worse. It's kind of on a not state by state, city by city basis in many states, because Arizona does have a state law that provides some restrictions, although some cities are figuring out ways to get around it. But in other states, it's city by city. Basically, one house across the street might be able to be used as a VRBO, and the one on the other side, because it's different jurisdiction, you can't. So you better know what those are, and also you better be aware of what might be coming down the pike on those as well, because you go in and say, okay, well, I'm going to purchase this property because it's going to be a great short-term rental, just to find out a year later that the law changes.
Yeah. Now, how do you think, it seems to me one of the best ways to keep up to date on something like this is just get a meeting with your attorney. One, if you don't have one, find one that you trust.
Mm-hmm.
This doesn't have to, by the way, be something that's very expensive or take a long time. This could be, we do this with our CPAs every year. Hey, what do I need to know for best tax practices going into the rest of this year, depending on when you do it? It's no different than meeting with an attorney, finding a good one that you trust, where you can really spend an hour or two tops going through what's unique to your industry and how you're going to prepare for that.
Yeah, for sure. I would connect with an attorney that is familiar with your industry, that's familiar with, business structuring and business and real estate transactions, if that's what the type of business you're engaged in. And then also, I know people don't like to be spammed or whatnot, but for example, our law firm sends out a quarterly newsletter. Make sure to sign up for those things with whatever attorney you're working with, because there will be, up-to-date information. Watch podcasts like this. Come to the Creative Finance Collective. I mean, we had a long discussion a few months back on the whole Corporate Transparency Act. Well, if you were there, you would have heard a lot about it. And so, tune in and just stay up to date.
All right. So we're moving to number 3 of the top 10 things that business owners should be looking at in 2024. Number 3, establish or review and revise your policies and procedures. So we put it that way because depending on the size of your business, you might not even have policies and
Right.
procedures. If it's just you and, it's just a holding company for maybe a rental you're doing, do you need policies and procedures? Probably not. As you add employee number 1, employee number 2, do you need to start thinking about that? Absolutely. So one would be if you're kind of in that small business size and you're growing and you're adding employees, you really need to start thinking about policies and procedures. What do you think, Sean? Do you think that really begins with employee number 1?
I would say with employee number 1, I mean, you and I, when we first started out, it was the 2 of us, and we had, Brian Locker as a contract attorney working with us. And, we really didn't need policies and procedures. But once we hired that first employee, we started thinking, oh boy, like we need to make sure that they're doing what they're supposed to be doing and how they're supposed to do it. And so we kind of started real small and wrote up a little, job description and policy and procedures for that. But then as we added people, we ended up with, a pretty large policy and procedure manual that we have now. And my recommendation, I like how we handle ours, which is we have firm meetings once a month, and we go through one section of the policy and procedure manual at each of those meetings. And as a result, we review and then revise, because inevitably, as we're going through, we realize, oh, you know what, that's changed. Maybe we're not using that software anymore. Or maybe we don't really follow that policy like we should. So maybe we revise it and kind of do with put in there what's working for us now. But basically, you should always have a policy and procedure manual. And how many times does something come up around our office, Andy, where we say, a question comes up, or somebody's like, oh, was I not allowed to do that? And we can always say, well, no, it's in the policy and procedure manual. Or if they have a question, well, why don't you look at the policy and procedure manual and see what it says? I mean, it is really one of those things that you just have to have to really operate efficiently as a business.
Well, and the other thing is I have found that employees appreciate it.
Mhm.
They understand the rules of the game, and it's not just the rules for them, it's the rules of the organization, the rules by which owners, employees, it doesn't matter, have all agreed to abide by. And it gives a level of credibility to your organization, company, what have you, that it doesn't otherwise have without it. Now, as Sean said, you're going to start with a template usually. And as your company grows, inevitably you find what works for you, what doesn't work for you. And there's this constant process to it. So if you do have it every year, or even like Sean said, we're monthly working through that, but at a minimum, you should be looking through and revising it in such a way that meets with your company culture, your company dynamic. But beyond that, we just talked about following and updating and understanding the laws as they apply to your industry. Well, there are certain laws that apply to all industries. There's what's called the National Labor Relations Board, the
Right.
NLRB. That's a federal group, and different regulations can impact different businesses of different sizes differently. So you need to know where you fit within that, what sizes, what obligations you have. You might find that certain policies that were proper and legal one year no longer are going forward and have to be removed. And that's okay. You just have to stay up to date on that. But we find that that's a pretty important piece for every business owner. And from a legal perspective, one that you really need to stay on top of as you add employees and have to massage as you add more employees. Because inevitably, the policies and procedures of a company with 2 employees is going to be very different than one with 50 or 10.
Yeah. Right.
It changes, and that's okay.
Well, and it's funny you should mention the outdated, policies that, now violate the law. I remember, when firm meeting where we went over a provision of our policy and procedure manual, and you came to me afterwards like, I don't think the law allows us to have that policy anymore. I'm like, what? And so we looked it up, and sure enough, even us lawyers, we had something in our policy and procedure manual that, fortunately you were knowledgeable enough about that area of the law to catch it and be like, I think we need to revise that. And we did. And we made sure that it complied, but you really, and which raises the other issue, which is, who should be reviewing and revising that policy and procedure manual, right? It
Right.
should be in conjunction with an attorney familiar with your practice area, and even an attorney familiar with like employment law. Is you should basically have numerous sets of eyes on a detailed policy and procedure manual. Like you said, if it's just a small, one or two employee type shop, maybe you can get away with a little bit smaller manual. But as you grow, and as this is going to really control, how your organization operates, you really should have multiple sets of eyes on there to make sure that everything is, exactly the way it should be and complies with the laws.
So let's jump to recommendation number 4 that every business owner should be considering in 2024. So number 4, operating agreements and bylaws, reviewing, either establishing and or reviewing and revising operating agreements and bylaws. I put in operating agreements and bylaws, not that they apply to every business, but operating agreements apply to limited liability companies, bylaws apply to corporations. So depending on the type of entity you are, maybe you're a partnership, you don't have either of those, and you have a partnership agreement. In any event, you should have on your calendar as a business owner the review of those governing documents that govern your relationship among your partners, among your officers, so on and so forth, to make sure those are up to date. Because again, laws might change, not just laws, but agreements that you've entered into with your partners need to be reflected in those documents. I think that's more often in those agreements the mistake that most business owners make. It's not usually making sure that their agreement complies with the law. The laws aren't that significant that they change. It's going to invalidate an operating agreement. That's not going to happen. It's going to be, we came to this agreement on how we were going to distribute profit going forward, or we did this buyout, and the subsequent agreements don't get updated, right? That seems to be the most common problem. And then a dispute breaks out, and now all we have to go off as lawyers is some oral understanding that these partners had.
Right. It's important to have an operating agreement. If you're going to be in business with somebody, an operating agreement is critical. Even if you're going to be 50-50 owners, and you can document that on your articles of organization and, file them, and you can say, oh, we'll let the statutes, do their thing and whatnot. I don't like that. You should have an operating agreement, even if it's, kind of an off the shelf operating agreement, that's fine. But really, in my view, if you want to really take your business and your organization to the next level, and you're going to have multiple partners, multiple people involved, with your enterprise, with your business, you really should go beyond just your standard run of the mill operating agreement, which, like you said, isn't going to be invalidated or whatever. The operating agreement should be more than just the statutory minimum that you need to operate within whatever state you're operating. Our firm's operating agreement, for example, is over 50 pages. The standard off the shelf operating agreement is about 10. So our firm operating agreement defines, like you said, pretty much everything that you can think of between the partners, and how we interact with each other, how we interact with the firm itself, with the company, how we're compensated, how that's determined on an annual basis, how bonuses are determined. I mean, even things like retirement, and the number of hours that you're expected to put in and work. And all of that is, part of what is in our firm's operating agreement. Our firm's operating agreement is very custom. It's definitely not off the shelf. But how many times, and we're always amending it and revising. In fact, I think we're working on our Fourth Amendment right now.
Well, that's just it. So much of this reminds me of the process of policies and procedures. You can start with what you think is going to work.
Right.
And our firm's over 10 years old. We've spent a good bit of time, but we have amended that operating agreement many times, and every amendment was educated by our experience and what we thought worked or what we thought would make it better. And I think we got a pretty darn good one. But it's taken the time to massage itself. And this isn't even a process of disputes, right? This is a dynamic process that has happened over 10 years with a group of partners that get along and by and large have not had any disputes. So even in a friendly environment, you can see how revisions are just going to be what you need to fit what it is that you're doing and what's unique to your business.
Yeah, that's exactly right. I mean, the operating agreement really can basically be the framework for your business from now until years to come. And, without that, it's almost like a body without their, skeletal structure. Like, it's just not going to work. You have to have that in place for really that business to put all that, meat on the bones and the muscle and everything else. You really need that operating agreement because it really is the backbone of the organization.
All right, so let's move to number 5. The number 5 thing that business owners in 2024 should be looking at here at the beginning of the year: review your employment agreements, or if you don't have an employment agreements, establish employment agreements. Sean, I think sometimes business owners get held up on employment agreements thinking, well, this is pretty simple employment. It's at will. Why do I need an employment agreement? Well, not all employment agreements don't always have to establish, an at-will price that you're paying somebody or anything else. There can be a lot of other reasons that an employment agreement might be necessary. Confidentiality comes to mind. For us as a law firm, that's an important piece. You need to really be thinking about things that are unique to your business, intellectual property, all of those kind of things that are important to you, and be thinking about what that would look like in an employment agreement.
No, that's exactly right. When we talk about restrictive covenants, there are certain restrictive covenants that, if put in an employment agreement, are going to be difficult to enforce. Non-competes in employment agreements are extremely difficult to enforce. In fact, I think there's a push for federal legislation that would eliminate, non-competes in total. And they're difficult because you're basically telling your employee who doesn't own your business, like, if you leave, like, you can't compete with me. Courts generally don't like that. They don't view that very fondly because it's, you have the business owner taking advantage of the little guy, if you will. But there are things that are more easily to enforce. The first one is, like you said, confidentiality. Hey, don't all of a sudden go talk on the street about every client that we have, and disclose all of that. Don't disclose stuff that is confidential, that's secretive, that's trade secrets, that, is the method of how we operate so that we're profitable. That's all protected or can be protected by agreement. Don't, non-solicitation provisions. Okay, you can leave and you can compete with us, but don't steal our clients and customers on the way out the door.
Yeah.
Don't take them with you. Don't contact them after you left. Go get your own clients. Go build your own client base. Don't take ours in the process.
Don't download all of our forms onto
Right.
some drive and take it with you.
Yes. And it happens. People will do weird things when they're leaving their employer. You would think that they would view their relationship with their employer as a fiduciary relationship, as they should, but they don't always, and they do things that are detrimental. They let's say they have access to all of the, software and websites and things like that. And all the passwords are stored, up here and not written down, and they leave and you call them, hey, can we get the password to the website? Because we need to get in and make changes. Oh, I forgot it. I don't have it. Right. So you have to have those types of things in place. Like, okay, on the exit interview or when you leave, or, you need to always, have two people having access to a website or piece of software or whatever, because, if something happens to them, you may not be able to get access to those things, or if you do, it's going to take a long time and be very difficult.
Well, I think what business owners oftentimes forget is some of their most valuable assets sit on Excel spreadsheets or in Word documents oftentimes, right?
Mhm.
And when you think about that, let's just say you're a creative finance business and you went and hired Sean to provide your entire creative finance contract package. Well, that didn't come free.
Right.
You had to pay money for that. You might have even modified it over time with your lawyer to make it even better. A lot of time and effort went into that. And, if you're training an employee to go do these kind of things and they're like, well, I could just take all the forms and just go do it on my own for free. You're like, well, yeah, okay. Those documents had a lot more value now that I think about it, so there's ways to protect that.
Mhm.
And to protect that kind of information, to protect those client phone numbers so solicitation isn't happening, and all those kind of things that are well beyond just the non-compete, and are important
Mhm.
things to be thinking about beyond just an employment agreement that sets forth the price and
Right.
terms of what you're paying the
Right.
employee.
Exactly.
All right, so let's move to number 6. The number 6 thing that business owners should be thinking about in 2024, and that's establish, review, and or revise agreements with third parties. So by third parties, what we really mean here, obviously an employee can be a third party, but we're really talking about individuals outside of your organization. And that can come in a variety of different contracts or forms. If you're in, the real estate industry, you're doing wholesaling, sub two, all of that. It's really all your contracts, right? And the forms that you use to get the deals that you're
Mhm.
doing. And some of this is a play off of some of the other things we suggested, which is know the law and how it's changing. But your documents need to reflect that. And obviously, especially, and you can speak to this more, Sean, but in the creative finance space where, we do our creative finance collective, we're talking with other lawyers to see what they're doing to try to make the forms better. The forms don't just stay the same, right? They get better over time as the industry grows and it's understood better. So that's one of the things you really need to be looking at is, are your contracts out of date? What do you need to add to it?
Yeah, that's exactly right. And it doesn't really matter, whether you're an investor. Obviously, the show is geared towards real estate investors primarily, but if you're a contractor, if you're a professional, if you're a property manager, if you do invest in real estate, you're a landlord, all your agreements you should take a review of, and maybe not only you, but have your attorney take a look at them and review them and make sure that they're up to date, make sure that they have all the right disclosures. Like you said before, we had some changes a few years back in Arizona on wholesaling, where you had to have language in there, otherwise you wouldn't in your purchase contract. Otherwise, you wouldn't have an enforceable purchase contract. So you want to make sure that, hey, has anything changed? What's out there? What am I, gonna miss? And make sure that all those agreements are up to date.
All right, so let's talk about number 7. The number 7 thing business owners should be looking at in 2024. Determine whether it's time to renegotiate your lease. We had a discussion with commercial real estate broker Darius Green, who's a tenant rep, just a couple episodes ago. You can go watch that. It's pretty good. But one of the things that we came away with, not just in our discussion with Darius, but in our own experience, it's really easy to forget about the lease. And that is for businesses that have space, that are paying for a lease. That is a big part of your monthly overhead, probably one of the biggest. And it's so easy to forget about. You think, well, we'll deal with it when the time comes, or when the lease gets, when the lease is close to expiration. Boy, in our experience, if you wait that long, you've waited too long and you're stuck, and your hand is forced, and you're going to be staying in that space, right?
Right. So our firm has been in 3 different spaces. Well, 4, I guess technically we're subletting from a law firm early on, but we've had 3 spaces that we called our own, different spaces, and each time we learned something. But this last time, we ended up where we're speaking to everyone from, right? Our Scottsdale office. Both of us are here in the Scottsdale office. We signed a long-term lease. In my view, couldn't be happier. We love the space. Darius helped us get in here. But in the process of this, we learned that, in my view, 2 years is not long enough. We started about 2 years from the date that our lease was going to expire, where we called up Darius and said, "Hey, Darius, our lease is coming up in 2 years. Is now the time?" And, "Oh yeah, let's get moving on it." And so he came to our office, and we started talking to him, and started going and looking at spaces, and nothing. We didn't find anything. We even looked at spaces in our old building that had come up, and it went on and on and on. And finally we found the space that we're in now, kind of after we'd given up, right? I frankly said, "Andy, go look at it," because I'd had enough. And you went and looked at it and said,
Pick anything.
yeah, you might want to come up here and look at this. So I did, but, and it is awesome. We love it. But, we were down literally starting 2 years, and then we found the space, and then finally, we negotiated the lease. Then it needed tenant improvements. So we met with the architect, and we drew out the plans, and we did everything. When it was all said and done, you and I were moving in to this space at, with the movers at like 3 a.m, and only half of our floor was done. And there were other, some furniture wasn't delivered and set up, and offices were empty. Our internet wasn't even connected at that point. I mean, we barely made it from the date that our lease expired in our old space to when we were supposed to be in this new space. We barely overlapped and made it a day or 2 late, and we were hosed. And we moved in when it was partially done, but we started literally 2 years in advance. So I say all that to say, now's the time. Look at your lease. If it's 3 years out, man, I would be getting on the phone with a Darius Green, type broker, and say, "Hey, look, I know you represent tenants. Maybe you have someone that represented you in the past. Let's start now." Because it is a process, and, don't wait. And the longer you wait, the less leverage you have in negotiations too.
Oh yeah, 100%. You
know?
you gotta remember that the place you choose might fall out during the negotiation process,
Right.
and you might have to start from scratch. We thought we started way too early, and in hindsight, we could have started even earlier. It takes
yeah.
every bit of that process, and be thinking about it now. Your leverage will be so much bigger. Even going into a space, you have an idea about how you think it's going to go, or how you think you want to maybe handle tenant improvements, whether you even want something with tenant improvements. All the things that you think going in that you want to do or don't want to do are going to modify and change throughout the process. And that's a constant back and forth with the potential landlord and what they're willing to do. That's before you even get to the lawyer process to negotiate the final points of the deal.
Right.
So we think it's important, something you need to have on your radar. All right, number 8 of the top 10 things a business owner should be thinking about heading into 2024. Establish or review and revise your succession plan. I would bet for most of you, you haven't even thought about a succession plan, or haven't thought about what would happen to your company if all of a sudden you weren't there to sign checks for the company or to sign agreements for the company. Most people haven't planned for that. That's a thing that really needs to be on your radar. We've talked about this on a variety of different episodes, but the legal consequences to an acting manager, CEO, owner of a company that happens to them if they are suddenly, because of accident, death, or otherwise, unable to run or operate the company grinds to a halt, right?
Yeah, and I think that is something that's lacking with a lot of real estate investors. A lot of real estate investors come to me and say, "Oh, we want to do asset protection and help us structure our entities and form entities and do all of this," and we do. But I always say, "Well, what about an estate plan? How about something at the top of this structure so that if you die or become incapacitated or end up in Europe and and for some reason, a COVID happens or a catastrophe that won't let you come back and manage your affairs for a few weeks or months or whatever. Do you have the right documents in place to allow someone else to do it?" And most are like, "No, let's just get the assets formed. I'm not worried about that." Okay. There is no succession plan. There is, and a succession plan is threefold in my mind. The first succession plan is what happens when you die? Who in your estate takes over, right? The second succession plan is, well, what happens if you become disabled? Who runs the company at that point? Maybe it's not the same person that would take over if you died and it goes to your estate, right? Maybe it's a trusted employee or somebody who can run the business and you have disability insurance in place that goes part to the business, part to you. So that's the second. And then the third thing that you need to think about is retirement. Social Security is not going to, cut it for most people. You have to have some plan in place for the day that you decide, yeah, I don't want to do this anymore.
You
So
need
who's
the
going to
exit
do it?
strategy.
You need the exit strategy, right? Who's going to do it and what does it look like? And, are you going to be paid royalties or a buyout amount or what is that going to look like when the time comes for you to retire? You've done all this work, you've built this business, and now you want to just enjoy the fruits of your labor. Okay. Well, you should have that in place. And that's part of, in a succession plan and can be done with an operating agreement with a buy sell, which I think we're going to talk about in a minute. But what is that? What does that look like? So three things you need to watch out for: death, disability, and retirement. Those are the three things that I think you need to make sure to have some plan in place to deal with.
All right, number 9 of the top things the business owner should be looking at in 2024. Sean just mentioned it, the buy-sell agreement. If you're thinking about this intelligently and proactively, you've been told to do a buy-sell agreement. If you haven't, you need to think about doing one. If you've done one, you need to consider reviewing it and updating it to the extent that it is necessary. What are your thoughts on the buy-sell agreement?
So I practiced in the area of business divorce for 2 years under who in my opinion is one of the top, if not the top, business divorce attorney in the state of Arizona. And I will tell you that was 2 of the most stressful years of my entire life. Because we use the term divorce because it really is, when business owners go their separate way, it is like a divorce. I mean, when they go into business together, it's like they get married. And when they divorce, it's like they divorce, they separate, they don't like each other, they hate each other. And yet you have this business that they've built generally that's successful that you need to now figure out, okay, who's going to run it? How's it going to survive? How's it going to operate when the 2 owners, or maybe more, but generally 2 owners, hate each other and can't stand each other? And so, the emotions ran high and the amount of money in dispute was significant generally. And so it was a very stressful time of that. My most stressful 2 years in the practice of law. But the one thing that I discovered in that whole process was that the buy-sell agreement, which I refer to as the prenuptial agreement for business owners, would have resolved about 90% of those disputes, because it's the prenuptial agreement. It provides what happens if the business owners go their separate ways. And, there's no arguing, there's no disputing. It's mathematical formulas where you plug in numbers and it spits out, you get this and you get that. And it's pretty straightforward. And, it covers a lot of scenarios. So the first scenario is, I just don't want to be we just kind of went our separate ways. We don't want to be in business together, right? The second scenario is, I still want to be in this business, but I don't want to be in this business with you. And so there's a provision on what you can do, maybe to buy out another, owner, type of thing. What happens if an owner engages in malfeasance? They embezzle, they steal from the company. What does that look like? It covers death. What happens when one owner dies? What money goes to their estate? Hopefully you have key man life insurance. Part of that goes to the business. Part of that goes to the estate. What happens if they become disabled? And then finally, what happens if they divorce? And all of a sudden the spouse, who, you may or may not know, but they get a piece of the company. Well, what happens then? And so there's provisions that can be put in there that deal with that and what that looks like. And, how that spouse or both, both spouses, the divorcing spouses, can both be bought out by the company or by the remaining members. But it is your prenuptial agreement, and it can resolve a lot of disputes. Instead of spending hundreds of thousands of dollars on litigation, you can spend, thousands of dollars. Sounds like a lot, but not in relation to what you would spend on litigation. You can spend, a few $1,000s on a buy sell, and, make sure that it's in place. And then you can utilize that to avoid, massive business divorce litigation.
Absolutely. All right. And now finally, the number 10 thing that you as a business owner should be thinking about and doing in 2024, determine whether your business holdings comport with your living trust. So what I mean by that, you may or may not have a living trust, but if your estate or businesses is of a particular size, the chances are you do have a trust. And we wanted to bring this up because what often happens with the preparation of your own personal estate plan documents and trust is that you do the documents and then you put them in a binder and you put it on a shelf and you forget about them. The problem with that is a trust, no matter how good the language is in the trust, it's only as good as what it owns. And where a lot of business owners fail to properly administer that is they form new LLCs, new businesses, or maybe even a business that was around prior to doing the trust, and they just didn't retitle the company information so that the company is owned by the trust. This is an important thing that can, if done incorrectly or forgotten about, can totally thwart an estate plan. So really what we're recommending here is check your own estate plan and make sure your LLCs, your corporations that you've set up, are owned or meet with your estate plan as it was designed to be set up. What would you add to that, Sean?
So a number of years ago, I had a client consult with me, and he came in and sat down, and he had this big binder with him of his estate plan documents. And he said, well, the title company said I needed to come see you because I can't sell my property. My wife died and I have to do a probate. Well, that's weird. Okay. So we looked it up because normally, husbands and wives own the property as community property with right of survivorship. So that wouldn't be an issue. So, well, that's weird. So I looked up the deed on the recorder's website and I found it. And sure enough, they took title as tenants in common. And so when they took title as tenants in common, that meant that if the wife died, her estate needed to be probated. And that was the most recent deed on there. And he said, I just don't understand. We did this estate plan before she died, and I thought it would have covered everything and I wouldn't have to do probate. So, well, that's interesting. Yeah. It looked like an attorney had prepared it. It was big binder, really nice tabs and, indexed and the whole thing. And so let's look. So I started looking through his estate plan. I get to the very last page And in a plastic sleeve is the original warranty deed from the husband and wife as tenants in common to the trust, sitting there unrecorded.
Oh,
Long story short, I kind of schooled him on how to talk to the title company, and I talked to the title company, and they accepted and acknowledged the document. It just didn't get recorded, and we were able to convince the title company to let us now record the warranty deed and hold it in the trust and avoid the probate. But I say all that to say that was an estate plan that was prepared by an attorney and ready to go, and yet it still needed probate. Things fall through the cracks. And so you may have gone to an attorney and think, oh, everything's good because I did this estate plan. But if you don't put your assets in the trust, it's not going to work. You're basically doing an in run around the estate plan. You're going to end up in probate. So if you go after you do your estate plan and you form an LLC, it's not going to, and you don't put the trust as the owner, it's not going to work. If you die, your heirs, your beneficiaries, they're going to end up having to go through probate to gain access to that LLC. Versus if you put it into the trust, if the trust is sitting on the top of your organizational structure and everything flows up to the trust and something happens to you, all your successor trustee needs is a copy of the certificate of trust and a death certificate, and they can do everything in your organization and handle all of your financial affairs. But if you don't do it, it's probate, and you could be waiting a significant amount of time, and it's going to be expensive. So to Andy's point, you need to look at how you've structured everything. And if you have that estate plan in place, you need to make sure that you put that trust within your entity structure so that everything flows up to it, so that if something happens to you, you have a successor who can take over and avoid probate and manage your business affairs.
all right. Good stuff. Well, everybody, that is the top 10 things for business owners to be doing in 2024. Make sure to join us this afternoon, 3 p.m. with the Creative Finance Collective. And make sure to join us next week, every Tuesday at 10 a.m. We'll see you next week.
Have a good day, everyone.